Howden.
My Lords, turning back to the merger price and why the Court of Appeal was correct to find that it was not reliable as an indicia of fair value. Can I start by going to the judgment of the Court of Appeal at paragraph 112, which is on page 90 of the bundle? That's where the Court of Appeal quote the judge's reasoning on this, that is, on the law. And you'll see that the judge said that, in his view, in my view, the merger price can be evidence of fair value where the transaction process was properly conducted so as to ensure the market was adequately tested. That's one thing, the market's adequately tested, and there is sufficient evidence that market conditions were such as to facilitate an arm's length transaction with all potentially interested parties. The summary given in Dell, and Dell, you'll know, is the case in Delaware concerning Dell Computers, where Michael Dell was buying back the company, but there was a very specific process to ensure that it was all done fairly. And the judge says the summary in Dell seems to me to be a good one with some minor modification. Where there is sufficient evidence of market efficiency, fair play, low barriers to entry, outreach to all logical buyers, and a well-designed sales process, the merger price should be given weight in the fair value determination. We say all of that's absolutely right. The precise weight would depend on the evidence as to how good and robust the process was, whether there were any market inefficiencies or problems that limited the participation of interested parties, or other difficulties that affected the company's ability to find a purchaser at the best price, and the weight to be given to other valuation methodologies. I accept that in a strong case, where the evidence demonstrates the factors identified in Dell were satisfied, it can be appropriate to give the merger price heavy weight, but I don't accept the dissenting shareholders' argument. There's an enhanced burden on the company to provide additional fulsome discovery on this issue. As with other issues in the fair value determination, the company needs to produce sufficient evidence to show that the conditions justifying reliance on the merger price were satisfied. If the company decides to limit its documented discovery and not to produce as witnesses those directly involved in the transaction process or the production of management projections, then it risks failing to satisfy the evidential burden. And that was an approach consistent, as he saw it, with Mr. Justice Cavalier in Nord Anglia and Mr. Justice Parker in Cunard. Now, if you could go forward, the Court of Appeal essentially agree with that, except for one point. At paragraph 138, they refer to
page.
That would be 102. They refer to Dell and the other leading case of DFC, and then on the next page at paragraph 139, they refer to Solera, where the Chancellor in Delaware said that he was taking guidance from DFC and Dell, and said that those decisions teach that the deal price is best evidence of fair value when there was an open process, meaning that the process is characterized by objective indicia of reliability. The indicia include all relevant factors and are not limited to, and first is robust public information, easy access to deeper non-public information. The next is many parties with an incentive to make a profit had a chance to bid, meaning there was a robust market check, outreach to all logical buyers and a go shop characterized by low barriers to entry. and a special committee composed of independent, experienced directors, and no conflicts of interest in relation to the transaction. And
were these Delaware cases ones where the merger price was treated as the only element, or were they ones in which it was blended, like here, with other factors?
I can't recall.
Because he says, he's talking about these deal prices, the best evidence of fair value.
These were cases where there was, again, argument about different things. I mean, in Dell, in particular, that was a case where it was found, and I think the Court of Appeal deals with that actually at 141. It explains what happened in Dell and how that was a reliable process. I can't remember what happened in Solera, I'm afraid. But and if we go to paragraph 145, what the Court of Appeal here said, so that's at 118, I think. No, 108, sorry. Where they said that in the second sentence, in the first sentence, they said that they agreed with the decisions in the Grand Court, the guidance in Dell and DFC as to the need for a market check in the circumstances in which a merger price may be relied on is equally applicable in this jurisdiction. The qualification relates to the sentence in the judge at 156 of the judge below, where he said that he didn't accept the submission that there was an enhanced burden on the company to provide discovery. And the Court of Appeal say, I agree the reference to an enhanced burden and additional discovery is not necessarily appropriate. But in my view, it is of fundamental importance, particularly in a management buyout, that companies give full disclosure of all documents relating to the sale process, including the market check, relevant communications with financial advisors. In a management buyout, the buyer holds all the cards because of its detailed knowledge of the company's position. There's a need to ensure a fair process which requires the company to be entirely open. The most effective way in which this can be ensured is if the company knows inferences are likely to be drawn against it if it fails to be entirely open and transparent. Now, in our submission, in Solera, there was only a merger price. There was no blending found. But in our submission, the Court of Appeal, in its approach, is entirely correct, and indeed that doesn't seem to be disputed, save I think it's being said that the references to the need to be transparent and open by the company, although it's difficult to see how one could object to that. And in this case, adverse inferences were not drawn, but the point that was made ultimately was that the company had failed to prove that the merger price was reliable. Now, the Court of Appeal summarized the key findings of the judge, and it rejected the merger price because the judge had identified such serious flaws in the merger process that the Court of Appeal said a reasonable judge could not rely on the outcome. So what was it they were saying? Well, you see it all set out, I think, at 146 in a number of sub-paragraphs. So leave aside sub-paragraphs 1 and 2, which just related to the weighting, where they were criticising the judge's approach in applying a greater weighting, but the subparagraphs that go to the process, subparagraph 3 is going to the special committee, and essentially no one from the special committee who was able to talk to what was happening was put forward, because Mr. Zhao was an unsatisfactory witness, unable to answer questions, and so the Court of Appeal say in the fifth line, the evidential position, therefore, there was no satisfactory explanation for many of the decisions taken.
That's not a complaint of an absence of evidence as to what was happening. It's an absence of explanation for what was happening.
I think it's actually both, as you'll see from when they go on to deal with other matters.
Yes, a bit later they do.
Yeah.
They do. But here, the lack of explanations is focused on not, we don't know what the special committee did, we just haven't had the explanation for why they did it.
Yeah, but it's actually, later on, it's also, we don't know actually what they were doing.
But pausing here, does that matter? If the court can see what was done, then it can take a view on the effect of what was done, even if it doesn't have any explanation from the parties taking the decision, explaining why they went about it in that way.
In theory, I would agree, but you've got to look at the totality of the criticisms that were made. The problem in this case was that you had no one from the special committee who was actually able to talk about both what happened and why it happened insofar as you could see things. And what you're, of course, concerned with is, in this regard, what steps were being taken by the special committee to secure other buyers. That's the real thing. And nobody was able to explain what steps they were taking or why they limited things in the way they did. But, the Court of Appeal actually...
difficulty I have is seeing why any of these factors do more than affect what weight you give to the to the merger price.
Well, my lord, the answer to that is, of course, all of this, ultimately, the question is, should you be applying any weight to it? Of course, you could look at some of these factors and say, well, they simply would have the effect that you would reduce the weight. What the Court of Appeal is saying, the cumulative effect of the criticisms, is that in these circumstances, this wasn't a merger price that could be relied on at all.
I know they're saying that, but, for example, they're not taking into account the factors that weighed the opposite way.
Well, what they're saying is that they are, and what they're saying is the criticisms are so severe that the countervailing factors don't actually balance them out or have an effect that you can continue to have place reliance on the merger price.
Well, why are they in a better position than the judge to make that judgment?
Well, they're in a position to make that judgment, I would suggest, because the judge hasn't properly considered what the effect was of these factors. If one looks at them, the next one, serious defects in the market. Can we just sort of look at them and the cumulative effect of them? Because I would suggest that the weight of these is pretty important. So the next one is serious defects in the market check carried out by the special committee. So competitors not being approached, and that's all considered in A, and then B, a particular buyer expressed interest and wanted to form a consortium, but the special committee didn't put the parties in touch. 20C, 22 potential bidders.
Most of them seem to be things that would have given greater comfort, that's the right word, if they had been present, like the greater possibility of a competing bid. But the absence of a competing bid, or even if it wasn't much chance of there being one doesn't in itself go to show that the merger price.
No, but, my Lord, I agree. And each individual one on its own might not. But what the Court of Appeal is saying is we look at the cumulative effect of these things. And my submission is that was a perfectly fair thing for the Court of Appeal to do. Or put it in look at it in another way. The argument that was being made to the Court of Appeal was the judge himself had found a number of serious defects in the merger process. He himself had said you need to have a robust market process if you're going to rely on the merger price. And in our submission, when you look at those, he didn't actually have any sufficient answer to that. I'll come to...
Well, I think that's where it may have gone wrong, in him saying if that sentence is taken as meaning, which I'm not sure it is when you look at the judge's, what he said in the round, that it's a necessary condition of attaching weight to the merger price that you have these factors present.
Well,
whereas I'm not even sure that the Delaware court can have meant that.
No, I don't think that. I don't think it. I'm not submitting, my Lord, that it's a necessary condition. What I'm saying is these are factors that need to be taken into account. But the more you see there is a failure to follow a fair process, and a process that is likely to, which is going to give you comfort that this is actually a fair value, then it becomes more difficult to rely on it. And it's for the company to justify reliance on the merger price. I mean, the merger price, very important to sort of step back a bit. There's no sort of there shouldn't be any preconception that the merger price is a fair value.
No, but then on the other side, you take into account that 98% of the shareholders were either happy or not unhappy with the offered price.
Well,
some of them were institutions that could be expected to take a fairly sophisticated view, and that has to go on the other side of the balance.
That is potentially so, but I would respectfully say that is a slight misconception of the position of the institutional investors, because firstly, there was no evidence from institutional investors as to why they voted or failed to vote and had their shares deemed to be voted, so that one's trying to infer a view from in the absence of evidence, when evidence could have been called from somebody to say, well, actually, we regarded this as a fair price. So that's the first thing. The second thing is they're being told by the company, we recommend this as a fair price, and they're being presented with the city opinion. Now, the question is whether the company was putting forward matters fairly. In other words, the premise of what they're saying is, well, we've done everything we should in order to solicit other bids, and this is fair. Now, the judge is saying that the process that had been gone through wasn't one, actually, which was designed to solicit competitive bids. We've got to remember there is a big danger, and this is one of the things that the Court of Appeal advert to, that where you've got a management buyout, the management have a big interest because they're going to benefit from it.
But this seemed to be quite significant. It's not said in this case that they had access to any information that outsiders didn't.
Outside of?
That there was any material non-public information, if that's the right jargon phrase.
Yeah. Yeah, I know what you mean. I'm not sure it's the right jargon, but it may be. The real issue here, though, it's what they did have access to is what dealings there had been with potential other bidders. That is something only the company knew about, and anyone, an institutional investor, wouldn't know that firstly, there had been limited outreach to other investors. Secondly, when, as it said here, when a particular financial buyer came along who wanted to form a consortium, they hadn't done anything about that. Then at E, you see the NDA, which there are two things that's important to note about the NDA. Just going back, at D you see that they didn't inform, the special committee failed to inform interested parties of each other's interest, and they were instead, three of them were told to contact the buyer group. And then at E, the NDA, whilst it didn't prevent other bidders coming forward, it would operate as a disincentive, but more importantly, as they say in the middle of the paragraph, it would be an obstacle to a bid, and its relevance, therefore, is that it is further evidence the special committee was not fulfilling its key task of proactively seeking out a competitive bid. Now, in our submission, that is important. As they say, if it were genuinely focused on that task, it's hard to see how it could have approved such a term. At F, points about the lamentable disclosure that was given. And so, in our submission, the Court of Appeal was entitled at 5, subparagraph 5, to conclude that the judge erred in the two respects that they set out. Firstly, that the judge was inconsistent with his own self-direction, which was that you needed a robust market check and outreach to all logical buyers, and that wasn't excused by saying, well, it's public knowledge that the company was in play, because if that were sufficient, that would actually be an answer in every case. And in any event, there's a difference between knowing a company's in play and being approached by a financial advisor seeking to encourage you to bid. So then the second point related to the judge reversing the burden of proof, where the judge, what the Court of Appeal says is that the judge said it was for the dissenters to show that, to prove by calling evidence that competitors had been shut out, but as Mr. Salzido submitted, that would put the burden on the dissenting shareholders to show that competitors were prevented from coming forward, whereas the evidential burden is on the company to show that the conditions justifying reliance on the merger price are satisfied, as the judge himself had said. So it was for the company to put forward evidence to show that the market check carried out was adequate to ensure that potential bidders were approached and given an opportunity to bid. And the company wholly failed in that.
Can I just take
yes.
you back to 163G, which is what's being dealt with here?
163G
in the Grand Court, which is at the bottom of page 325.
Yes.
Where the judge says, in my view, the dissenting shareholders overstate the adverse impact of the failure to include competitors, and then says, I do not consider it's been shown that such competitors were shut out from, prevented from participating in the process, or from coming forward to express their interests had they desired to do so.
Yeah.
And then there's this, which is what I'd really like your help on, together with another passage. It seems to me likely that had these competitors had a real interest in making a bid, they would have had sufficient information about the fact that the company was on the market to allow them to contact the company or city and express their interest. The fact it had been on the market for some time supports this view. And then, just forgive me if I can just take you to another passage, which is at page 434, much later in the judgment.
Could you give me the paragraph number?
It's paragraph 340 little c,
yeah.
page 434 of the electronic bundle. Where at B, the judge has identified that not all the Dell factors or DCF factors, if I can put it in that way, were fulfilled. Not all the requirements are satisfied. There was a market check process that, whilst efficient, was sufficient to demonstrate an adequate level of marketing of the company to show that it was likely that all interested parties, including strategic purchasers, could have pursued their interests if they wished to do so. Now, obviously, the Court of Appeal focused on what the judge found were deficiencies in the process. But would it be right to say that it would also be relevant for there to be an assessment of what the effect was of those deficiencies in terms of the extent to which they bore on whether or not they impeded offers being made? And if that's right, are these findings of fact on the balance of probabilities? That it didn't, in fact, on the balance of probabilities, prevent bidders coming forward?
The difficulty is this. One thinks about what one's talking about. And in my submission, this is not the correct approach. Let me explain why. What you're concerned with is a process, and the purpose of the process, in very simple terms, is to elicit competing bids for the company. Now, if you don't follow the process and no evidence is called from anybody in the market, i.e. the alternative competing bidders, in my submission it's very difficult to draw a conclusion as to what would have happened. I mean, there's no evidential basis for saying what would have happened. And this is part of the judge's approach, I would suggest, of mixing up the burden of proof, because he's treated the dissenters as having the burden to call evidence to establish that alternative bidders were put off. But in our submission, it's in relation to this issue, that's the wrong approach. Again, what you've got to bear in mind, what is the issue that you're asking yourself? You're asking yourself, is the merger price an objective indicator of the fair value of the company? Now, it is if you are satisfied that that reflects what market participants would pay. In other words, you've had a competing process. But if the process, let's assume you haven't done anything, take an extreme, to market the company, then you couldn't draw a conclusion that, well, if we had, it would make no difference, unless you called appropriate evidence. And there just wasn't any evidence about this from alternative bidders. So it's all based upon the judge saying the dissenters didn't call any evidence themselves.
Okay.
I mean, the first paragraph you showed me actually shows that, because that was 163G, where the sentence that you read out, where the judge says, I do not consider that it has been shown that such competitors were shut out from participating in the process or from coming forward to express their interest. It seems likely to me, had these competitors had a real interest, and so on. And that's what the Court of Appeal was referring to in the paragraph I highlighted at 146, subparagraph 5b. And in our submission, the Court of Appeal are entirely right to say what the Court of Appeal has done is reverse the matter. So to complete my answer to my Lord, assume evidence had come forward. Let's say the company had called 3 or 4, whatever, some evidence from people in the market. And people in the market had said, well, we didn't want to bid for this because we thought the price was too high and we didn't think it was worth it, or so on. Then the judge, you might be able to say, well, even though there were deficiencies in the process, it didn't make any difference. But where the company called no evidence, and all you've got is well, you've seen what we've got from what's recited. In our submission, the judge's approach was infected by the idea that it was for the dissenters to call evidence.
But also, what he then went on to say about it being likely, you say, what wasn't a finding he was entitled to make because there simply wasn't any evidence to support.
Exactly. I mean, it's... That is what I'd say. So that's the market exercise. You've then got, which is allied to this, the inadequacies of the special committee and the role of Mr. Gow, which the Court of Appeal deal with at subparagraph 6. So, in our submission, there were a litany of failures. Now, added to that was the Court of Appeal's findings about the city fairness opinion. Now, it's in fact, the position is that the fairness opinion and the deficiencies in the fairness opinion were additional findings. But I want to say, in other words, the decision was not based, the Court of Appeal's decision was not based upon its view of the DCF valuation, but that was an additional factor. But if we go to that issue, and in my submission, the Court of Appeal was right in what it said about the fairness opinion, and if we pick it up by just following the logic of the Court of Appeal's judgment.
It was based on that, wasn't it, in part, as well as all the other factors?
Yeah, I mean,
it wasn't just an add-on after they'd come to their conclusion.
It was one of the factors,
yeah.
But it's the... I can't remember what the number is. I think that it's the number...
Well, it's the last one they got.
And it's the ninth.
Going through them, I think.
Yeah.
It's one of the ones.
It's very line, I think.
Yeah.
It's the ninth factor.
But at 148, it's not in the first 5.
No.
Yes, it is. It's number 4.
Yes, the deficiencies in the fairness opinion. Now, but in any event, it's all I'm saying is it's one of the factors. But it's not. I don't want you to get me wrong. I say what their criticisms of this were entirely correct, but it's not, as it were, the sole point on which everything turns, which you might have got the impression earlier. Now, if we could go back to paragraph 123, where the Court of Appeal deal with the fairness opinion, that's at page 98. So at 123, they recite the fact that for the DCF, City took a cost of debt figure of 13%. And the critical point is there was no explanation of how they'd arrived at that. Whereas in relation to the DCF carried out by the court, the two experts, Edwards and Glass, had taken a figure of 4.9 and 5.5%, and the judge had agreed with Glass that 5.5% was the correct. So you've got this delta between 5.5 and 13. Now, the Court of Appeal then, 1 to 4, refer to this evidence of Miss Glass in the second sentence, and it's important to note how they've summarised it. We look at that she said it was high, but there might, and it's very important that the word might, be some justification. Then the judge had said, in the absence of access to the model or discussion, she'd said it wasn't possible to conclude it represented an error. And then at 125, they set out the judgment, and you see the judge said in the middle that the figures used, in view of the figures used by Mr. Edwards and Miss Glass, 13% seems very high, but he accepted Miss Glass's view. It wasn't possible and only speculation to form a view as to whether a review would show that the high cost of debt was based on justifiable assumptions and did not, when the model is viewed in the round, result in a material undervaluation. Now, at 127, the Court of Appeal explained why that approach was plainly wrong. And they say one starts from the position that 5.5% was the correct cost of debt figure, and that was reached after hearing the evidence of the experts. So 5.5 is what the judge had decided. Then at 128, it's not surprising that he found City's figure hard to justify and seems very high. And if you translate that into ordinary legal parlance, that means, as they say, on the balance of probabilities, it was too high. So, but they then say that the judge took the view based on Miss Glass's evidence that there might be a justifiable reason for the figure. But that was merely speculation that it would have some justifiable assumption. It didn't constitute evidence there was a justifiable assumption, and so on. Now, in our submission, this is all unimpeachable. The figure of 13% on its face was wrong, and there was no explanation or no evidence from which you could justify it or say that it's a matter of swings and roundabouts, and that this was corrected elsewhere. Now, Miss Glass's evidence was
wrong to apply a balance of probabilities test, though, I think, because you don't go through each element of the calculation and think, is it more probable than not that this is correct? If so, I'll include it. If not, I won't. The balance of probabilities comes in when you're looking at the overall burden of proof, not at each tiny element of the whole calculation.
I know that's a point your Lordship's made on several occasions.
Probably.
My Lord, none the worse for that. I don't object to that. Anyway, I'm not in a position to object. But part of what your Lordship is saying is right, and I would say partly wrong. It just depends on the question you're asking. Now, it is fair to say the correct question is, well, what is the correct question you're asking here? Correct question you're actually asking, is the merger price reliable? Now, one factor that's being relied on to say the merger price is reliable is that City provided a fairness opinion. Now, the question is the fairness opinion that City provided, is there any weight to be attached to that in this discussion? Now, in essence, the answer is there's no weight that fairly can be attached to that, because you can see there is a factor in there which appears to be erroneous, and absent some explanation for it so that you can satisfy yourself that the City valuation, the City opinion is still reliable, that takes out one of the building blocks for saying the merger price is reliable. And so what you've got, I mean, in very simple terms, you have an opinion from City which includes a DCF valuation. The DCF valuation includes a cost of debt of 13%, which everybody accepts is wrong. And it was also accepted, you've seen that the Court of Appeal accepted, and it's at page 118, that if you adjust that 13% and you put in 4.9 or 5.5%, then and this was the evidence before the judge, that would have doubled City's estimate on a DCF valuation. In other words, just looking at it, you see they've got the wrong figure in. The judge had evidence of what happens if you put the right figure in. It has a dramatic effect on the DCF. Now, how can you then say, well, I can rely on this opinion, which appears to have an error in it? Now, whether it actually does and whether that error is corrected elsewhere, that's purely speculation. It's possible, obviously City are a respectable investment bank. It's possible that they did correct it elsewhere, but one simply it does not know.
What do you say about the check that the expert, Miss Glass, made, which he said gave some thought to relying on?
I say that is nonsense, and I'm going to go to that now.
Tell us why. You're going to address that.
I'm going to go to it right now, because we say that is actually not the case at all. So that's in the bundle at page 511, I think. 511. Sorry, say that again. No. 5111. Sorry.
Okay.
No, sorry, I've got it. So the paragraph that you were taken to was 175 of Miss Glass's judgment, where she says, I agree that without access to City's underlying model, certain adjustments made by City appear unusual. However, that does not imply their analysis was in error. The footnote matters. Since City's financial model is not available, nothing can be gained by trying to determine what City may or may not have done based solely on hard copy printouts. Instead, I reran City's analysis using my own model. That is, I performed a DCF analysis based on Trina's projections along with a discount rate of 11.6, terminal growth rate of 3%, and a valuation date of the 30th of September, all of which are City's assumptions. My analysis resulted in a fair value of $10.98, which approximates to the $11 determined by City. As a result, I have no concerns about any alleged errors in City's DCF analysis. Now, what she's saying, what she's done, is she has taken her spreadsheet, and what she's done is just
just done the maths.
She's just done the maths. It's just saying mathematically it comes out correctly.
But the cost of debt, their figure is built into the discount rate, as I understand it. Is that right? It's affected the discount rate, so that if there was an error in that figure which affected the discount rate, then it won't show up in her.
No, I mean, that's right. All that the very simple point is the point your lordship, I think, had got to, is this is just a mathematical check, because in these calculations, people apparently frequently make mathematical errors. I mean, the reason for that is if you put in one wrong element in your input, press the wrong button, and you get the wrong number. So she's checked the numbers. She didn't have any explanation beyond speculation as to what had happened and whether or not there was some corresponding adjustment.
Yeah.
So in our submission, there is no basis at all for saying, which is really, my friend's argument is this, that really this is all a matter of swings and roundabouts, and that and the argument that Miss Glass was making I think amounts to this, that actually City made two mistakes. There were two mistakes. One was that they had the wrong cost of debt, 13% instead of 5% but the second is they had the amount of debt wrong. So it was 70% instead of 50%, And then I think what they're saying is, well,
They cancel each other out.
they somehow cancel each other out. But the difficulty with that is, firstly, it's speculation, and secondly, well, by how much do they cancel each other out? I mean, what is the effect of any of this? Now, we simply don't know, and that's why the Court of Appeal were right to say that in circumstances where what the company is trying to do is to justify the merger price, and where one ingredient of its argument is that we had a city fairness opinion, if you can't say the city fairness opinion is reliable, and in our submission you can't, that takes out one of the important legs of the argument. And indeed it's more than that, because it also then infects the argument based upon the other shareholders, because the institutions who, we've discussed this in part, certainly, as the Court of Appeal recognised, an important factor, it is to be inferred, is the city fairness opinion. And if you can't say that was reliable, then it's very difficult to say, I mean, we'd say you can't draw anything from the other shareholders, but it becomes even more difficult where you have material being supplied to them which at least has not been shown to be reliable. So in our submission, the Court of Appeal was right to draw the conclusion that it did at page 118 at paragraph 148, that I think there are 6 points they highlight. The significant deficiencies in the market check, management buyout with potential difficulties and conflicts of interest, material risk that Gow's position had a chilling effect, deficiencies in the fairness opinion, concerns about independence of the special committee and whether they're willing to act adversely to Gow's interest, and the complete failure of the company to produce relevant evidence. We would suggest the Court of Appeal was right to say that you cannot rely safely on the merger price, and to do so is contrary to the jurisprudence that has grown up in this jurisdiction and in Delaware in relation to these matters. Now, that, I think, is subject, unless there's anything else you want to ask me, I'm going to move on to a point we've addressed in part, which is the weighting. So now, the premise of this part of the submissions is obviously that we are right that the merger price should be, as it were, knocked out of the picture. So now, in our submission, one needs to...
Before you get on to that,
yes, of course, Margaret.
If on ground one the conclusion was the Court of Appeal were wrong to find the judge could not place any weight on the merger price,
yes,
it's a question of how much weight. He's placed too much weight. What then?
Well,
it's not reasonable to conclude that there should be no weight on it, but there is some grounds for saying he's placed too much weight.
yes. Well, obviously, going back to the approach of an appellate court, in that situation, the first thing the court's asking itself, has the judge reached a decision that no judge could reasonably reach? So the answer to that is no, but I think your lordship is then saying, but what if we think some weight should be attached, but rather than zero weight? The question then is, does this court, is it in a position to assess the matter, or does it remit the matter to, I suppose it would be either the Court of Appeal or the judge at first instance, but I think it would be the judge at first instance. I think if you got to that position that the judge was wrong and the Court of Appeal were wrong, I think the only sensible way to deal with it...
For the judge to redo it on the proper basis.
Well, I think the judge would have to redo it, where this court would be saying, we don't think it right in the light of the criticisms to give it a 45% weight. No. Therefore, we think, in the light of the criticism, we accept some weight could be attached, and the judge would have to then reassess de novo against the facts he's found. So it would be a sort of, I mean, he wouldn't
have to have another trial. He would just go through the submissions.
Well, it would be a limited trial. I don't imagine Mr. Justice Siegel will be happy with your lordships if that's where you want to go. But I think that is the logic, that if you didn't accept you didn't accept either party's submission, and that some weight has to be attached to merger, I think there's no choice but to throw it back.
Okay.
And the same will come perhaps on the weighting question, if we don't think the Court of Appeal were right to having knocked out merger, to say that it necessarily follows that market should stay at 30%.
If your lordships were of that view, then it would be difficult for me to say anything other than give the same answer, namely that it would then have to go back.
Yeah.
But there is a more complicated issue in relation to that question. If you're with me on the first point, it's a point we've already discussed, but as to what properly the Court of Appeal should have done in the light of the submissions that were put before it. And in my submission, that is an important point. Now, and I think that there's a danger of slightly mischaracterizing what the Court of Appeal did. You have to remember, what was it that the dissenters were submitting? They were submitting that the discounted cash flow, the DCF, should get 100% weighting. And there should be no weighting to merger and no weighting to market. Now, and that was the only issue before the Court of Appeal. Do we accede to those submissions, and or to what extent do we accede to them? So what the Court of Appeal has actually said, well, we agree with you that merger's out. As to market, we don't agree, but we're therefore going to discount what you're saying, the DCF. We're not going to give it 100%. We're going to give the market 30%, because that's what the judge had said. And no one was arguing it should be higher than 30%, including in this context. Now, in my submission, it would be, if one imagines a judgment coming out of the Court of Appeal in which they had said, well, we agree with the dissenters, merger's out, but although the judge said 30% for market and the company wasn't arguing for more than 30%, we're now going to increase it to, let's say, 50%. In my submission, that would have been entirely wrong, because they would have been doing something that hadn't been argued and wasn't part of a case that was being put before them. So although your lordship might say, well, there's a logic for saying you need to reappraise these percentages and the 30%, where that wasn't part of what was being put before the Court of Appeal, in my submission, they were entitled to just consider, the only point that's being put before them, is it 30% or less?
Well, but the 30%, their argument was premised on them that being proper because the market, because the merger should be given the weight. Another way of looking at it was simply that the Court of Appeal's decision left a black hole, as it were, for part of the element of the price, and nobody had actually specifically addressed that situation.
Well, but that's really my point. It was for the company to say, well, if you're going to disturb them, either merger or market, then what you've got to do is adjust the percentage that applies to the one that's left. And the company chose not to do that. And in my submission, that raises a point of principle as to whether they can come before this court and say, well, somehow we didn't argue it, but the Court of Appeal went wrong, notwithstanding that. And in my submission, it's not fair to the Court of Appeal, as well as to the dissenters. It's not a fair criticism of the Court of Appeal in circumstances where they weren't being asked to do that.
Should the Court of Appeal not have called for further argument on the point?
I don't think so. When the parties were ably represented, and as the Court of Appeal remarked, no one was asking for an increase in the 30%.
The Court of Appeal was left with something of a vacuum, having decided not to rely on the merger price. And the assumption was, the assumption which followed was that should be filled by the DCF.
Yeah, but my lord, that was the argument the dissenters were making. The argument, that's what you have to remember. It's not a vacuum in our process. The dissenters are saying 100% to DCF, i.e. nothing to the others. But so it was necessarily before them. If we're going to have either of the other two, what weight do we attach? So it wasn't, as it were, a vacuum in terms of submissions. It's just that was the position the parties took. I mean, it's rather, essentially, the company took an all or nothing position.
Well, couldn't you equally characterise it by saying that the company were arguing for only, was it 25? What did the judge come up with for the DCF? 25%?
25%.
They were arguing for only 25% DCF, but it should be as, if they didn't succeed in that, it should be as little as possible.
No, that's contrary to how our procedure works. The company, before the judge, had argued actually for nothing on the DCF. Yeah. They lost on that, and 25% was awarded. We then appeal and say it should be 100% for the DCF and knock out the other two. They didn't put in a cross notice saying, well, in the event that you knock out merger or market, there should be a corresponding increase in the one that remains. And that's under our procedure, what they were required to do. And if they don't do that, then it doesn't behove them to come today and say, well, the Court of Appeal should have somehow given us a further opportunity to pick up my Lord Jones' point.
The Court of Appeal didn't put everything on the procedure, though, because they said, well, they thought that that was the right thing anyway to leave it at 30%. Had they not thought that was necessarily the right thing, they might have called for some further submissions rather than just take a procedural point.
No, your lordship is right, but here now there's an appeal from a Court of Appeal, and in my submission, where a party hasn't argued a point in the Court of Appeal, it can't then say, well, I would have argued this, which I think is the way they put it, or some other approach should be adopted. And one has to remember the Court of Appeal did consider let me just find it. Yeah, if you go back to paragraph 30,
yes.
Sorry, paragraph 35. where they are considering fair value, they accepted the following submissions. So the first is that a true worth of a share can be assumed by assuming an immediate sale, and they recognise that will often be the most reliable method. But true worth can also be assessed by assuming the shareholder retains the share and obtains the financial benefits. That's sometimes called intrinsic value. And a DCF can assist and be relied upon on either approach, and that's important, either directly as a model of what the shareholder will receive if the share is retained, or indirectly as an estimate of what a purchaser would likely pay for the share if sold. And then over the page, they said that the selection of valuation methodology or methodologies is a fact-sensitive issues, and in some cases it would be appropriate to give particular weight to market-based indicia of value and use a DCF as a means of testing. Thus, where the adjusted trading price and merger may be seen as reliable, they may be used as a starting point. Although the judge didn't specifically say this, it's implicit in what he says, and I would hold to be correct, that in other cases it will be appropriate to estimate fair value exclusively or primarily using a DCF. And of course, I'm sure you're all familiar with a DCF. I mean, a DCF is intended to reflect the value of the asset, and so should reflect what people in the market would pay. I mean, essentially, it's looking at, if you have a widget factory, what over the period of time, including the terminal period, you can earn from the widget factory.
Well, if you'll earn 3 times as much as the market price, then the shares are an incredible bargain.
Well, that of course assumes, and there's a big assumption, that market price is reliable.
Absolutely.
And Court of
That's
Appeal,
where you look at whether there's, whatever it's called, I keep forgetting, material non-public information.
No, that's the market price. Sorry, we need to not be confused the merger and the market price. The market price here is based on a number of assumptions, as we said, because you're trying to recreate what the market price would be. So in other words, if you've got a situation, I mean, if you look at the price of a share today, I mean, that's of a publicly quoted share today, then that prima facie represents the market price. Now, there could be a question as to whether that is fair value if you can show that the market doesn't have some information. Here, though, you're not looking at the actual trading of a share. You're looking at what an expert is saying the share would be traded at. And the Court of Appeal and the judge said there were considerable problems with the exercise that had been done. For instance, there weren't event-based studies. I don't know whether you
I remember
picked up that.
Now,
yeah. The detail doesn't matter, but there were considerable difficulties with what was said to be the market price.
But the Court of Appeal seemed to have assumed that provided you have enough experts and a long enough trial, the discounted cash flow will be the sort of true value of the company. But that has its problems, because you're trying to project what it's going to earn in 7 years' time and then discount that back into a present price, which is all sorts of
right, but with respect,
subjectivities.
With respect, there's one word in there that's wrong. It's not about true value. We're not...
some of these expressions that they seem to like to use, like it's real worth, seem to...
Well, but the exercise under Section 238 is about what is the fair value of the shares. Now, a DCF is a means, I mean, it's actually used all the time, DCFs, to value companies and to value assets. Of course, it is dependent upon the inputs, and so it will have, I mean, its critical input is forecasts going forward of the cash flows of the company, and so you're having to project here in relation to a company in the solar panels business, what's going to happen over the forecast period. And so obviously you can be wrong, but that doesn't, I would suggest it doesn't make it, and I think a lot of people in the financial community would be surprised if one said, well, this means it's sort of an unreliable tool.
No, not inherently unreliable. Obviously, it's reliable. It's going to vary according to how easy to forecast it is. But it also depends what purpose of the two you mentioned or using it for.
What the court is doing and did in the trial here, it is assessing the reliability of the data and then coming to a conclusion as to what it regards as a reliable DCF, and what the output of that is as to show the fair value of the company. Now, so in other words, it's not saying this is the true value. No. It's saying this is what the fair value is, and so on.
But speaking for myself, expressing these concepts by reference to what is reliable or not reliable,
yes,
is putting it in a binary way, which isn't the exercise one's involved in. For each of these methodologies, the judge's view, and in a different case, let's assume it's a valid view, is there is some uncertainty about each of them. You can't say any of them is 100% reliable.
Yeah.
So when you then get to the stage of what you're doing in your weighting by ascribing different percentages to them, is you're not only looking at how reliable the factor is that you're looking at how reliable it is compared with the unreliabilities of the other factors. So if you take your merger price and you remove that completely, the assessment of how unreliable a DCF is, it infects how you reallocate. Because how unreliable it is. If you've only got two to choose from, then you're in a different situation from where you've got three to choose from. I don't have to put that very clearly.
No, you've put it extremely clearly. I mean, if you've got two to choose from, that's different from choosing from three. Even I couldn't argue with that. But the issue that was considering, I mean, sorry, let me start again. If you start with a blank piece of paper and you say, well, I've got these three methods, and I think I need to blend them. So I need to, as you said earlier, I don't think any of them is completely satisfactory, and I'm going to blend them. And the reason I'm blending them is that will reach an aggregate value, as it were, of the three, and that is what I regard as the fair value, because I'm taking account of each of these. And then I'm weighting them, and what I'm doing by weighting them is, well, what am I doing, I suppose, is part of the question. Am I trying to weight them because of the issues I have with them, or am I weighting them by reference to each other, or am I doing something else? Now, in our submission, what the way the Court of Appeal interpreted what the judge had done was to treat the 30% weighting for the market value, as it were, in any circumstance, the maximum value you could put on it. That it could never, and based upon the expert evidence, should never have more than the 30% weighting in the exercise. Now, I understand the criticism you're making, and Lord Legate's making, is, well, surely that wasn't logical where you were where the judge intended to give market-based valuations a higher weighting. But the difficulty with that is that the market-based valuations, I mean, his view that there should be 75% was premised upon having both merger and market as part of the picture. And once merger went out of the window in our submission, that reasoning simply ceased to apply. And that's one point. But the second point, which I've already made and I won't repeat, is that was the only issue before the Court of Appeal was 100% to DCF, or is effectively 70% and 30%. And their decision was 70 and 30. Now, there's a further point which is worth bearing in mind in relation to the weighting, which is to remember how this all arose. Now, the flaws in the merger process were ones which had the effect of reducing the merger price. So the merger price was too low as a result of the deficiencies, or at least
I don't think you can say that of all of them. Some just made it less inherently reliable, didn't they? Like the lack of competing bids. It just means that you didn't have an independent check on it. Doesn't itself show that it's too low?
It's the likelihood is that it was too low. Let me just expand on that. Right. The deficiencies in the process, particularly the role of the special committee and their failure to stand up to Mr. Gow, Mr. Gow's the lack of independence, Mr. Gow's role, and the failure to then put the matter properly to competing bidders, at least leads to the view that the likelihood is that if that hadn't been the case, that there would have been competing bidders at a higher price.
Why?
Well, because one has to ask, why were the...
Unless it was a sort of calculated to keep out the competing, but I don't think it went that far to suggest that.
And for instance, the NDA, you remember I showed you what the Court of Appeal said about that the NDA was inconsistent with a special committee which was seeking to secure alternative bids.
I think you're reading it quite far if you say that what was going on was sort of machination, because everybody knew that it was being bought out at a low price. If you allowed any competing bidders in there, they'd come in with a higher price.
Yeah, that would be overstating it. Yeah. All I'm saying is that you've got a situation where the process has failed in the way it's described in the jurisprudence to seek to secure competitive bids. So all I'm saying is the likelihood is that the direction of travel is only one way. In other words, it is very unlikely if you'd done all of this that you would have ended up with bids that are lower rather than higher, and not least anybody who's coming in is going to have to bid at a higher price.
But if you'd had an open process, nobody might have bid, because they all might have thought that the price was high enough as it was. No, all it shows is you can't rely on it, doesn't it?
I think we may be at cross purposes.
Right.
Let's take your point. All it shows is you can't rely on it. But the important thing to remember is the merger price is higher than the market price. Yeah. So, and the market price... Well,
there would be something wrong if that was if it was lower than the market price. I mean.
Yeah, but the point is, by seeking to increase the percentage of the market price, what you're seeking to do is to reduce the fair value. So, because the merger price has gone out, and you're then saying I'll increase the percentage of the market price, which was itself deficient, resulting in a lowering of the fair value and the sum that will be paid to the dissenters.
Well, it probably still have gone up if you'd say put 40% on the market price and 60% on the DCF valuation.
Well, it may or may not, is the answer, but the point is the direction of travel by increasing the market price is potentially to reduce the fair value. I mean, Your Lordship, I'm not sure Your Lordship's necessarily right. So when you had 45, 30, 25, if you now went to, let's say, 50-50, with the market price going up considerably, because the market price is way below the merger price, that is going to have a considerable...
It's not way, but actually it's 7 compared with 11,
well,
I think. But on the other hand, the DCF is now coming out at 18 or 22.
Yeah,
so I would have thought giving greater weighting to that is going to, even if it's not much more weighting, it's still going to put the overall fair value up.
But all I'm saying is that the direction of travel by increasing the market price, which the court has already... I mean, Miss Glass said had problems. That was her own evidence, and and the judge said he wanted to discount it further than she did, although, as we know, he actually put it up to 45% rather than down from the 40%. All I'm saying is that it's an illogicality or an oddity to increase the market price when the merger price has been knocked out. And the Court of Appeal at page 165
Paragraph or page?
At paragraph 247, it's worth picking up at 246. There's 246 is also where they there say that, as the Delaware jurisprudence makes clear, where there's a semi-strong efficient market and where the transaction process has been robustly carried out, the merger price is likely to be, and possibly the most reliable indicator of fair value. However, where the sale process has not been robustly carried out and there are other deficiencies, as described earlier, that no weight can be placed on the merger, a DCF valuation is a very appropriate methodology, subject to, of course, to any weight which may be attributed to the adjusted trading price. So just stopping there, it's perfectly clear there, the Court of Appeal their view was a DCF valuation is very appropriate, subject to the weight which may be attributed to the adjusted trading price. Then at 247, they said that given their view that no weight should be placed on the merger price, they didn't need to address the submission that it's wrong in principle to give weight both to the merger price and the adjusted trading price when there have been defects in the sale process which are likely to have skewed the merger price and where the adjusted trading price is lower than the merger price. To do so is to skew matters even further. Suffice it to say that at present I see the force of that argument, and I note the judge's observation that he wasn't aware of any case in Delaware or this jurisdiction where weight had been given to both the adjusted trading price and the merger price. And then they said, I would add, I don't see that the same argument supports the suggestion we should give no weight to the market price simply because we're giving no weight to the merger price as a result of deficiencies in the sale process. If there's a semi-strong efficient market and no MPNI, the authorities are clear that some weight can be placed on the adjusted trading price as an indicator of fair value, and this must still be so even if no weight is placed on the merger price. Whether it would be appropriate to do so, and if so, the comparative weighting, which should be placed on the adjusted trading price and the DCF valuation, will depend upon the particular circumstances. So what the Court of Appeal was saying is that in the circumstances of this case, having considered the criticisms that were made of the market price, having considered the jurisprudence that shows a DCF valuation can be a very appropriate methodology, their conclusion was, here and in the passages we saw earlier, that the weighting should be 70-30. So, my lords, those are my submissions on weighting. I'm not going to say anything about reliance on the analysts' reports, because that only arises, which I don't think actually is going to arise, because it only arises if one was going to increase the weighting, which I don't think is seriously being argued for. So I'll move on to the two ingredients of the DCF, which the Court of Appeal modified. Now, it's actually important to stand back for a moment and not get distracted. Again, I think my Lord Legate was saying, well, it seems a bit odd where you've got a DCF with a lot of components that the Court of Appeal tweaks one or two components. But I would suggest that's not quite the right way of looking at it. What you've got is the critical ingredients of the DCF. And the Court of Appeal, I mean, there were a number of arguments about defects in the judge's approach to the DCF, but only two hit home. And what the Court of Appeal was saying was these two were important ingredients. You could see that the judge had got it wrong, and so the Court of Appeal was correcting those, as indeed I would say it was duty-bound to do. Now, of course, if you saw errors in the DCF and you said, well, overall, there might be errors in this component, but overall the result is okay, then you wouldn't correct it. But if you could see there are components which were wrong and that had skewed the result, then one could and should correct it. So turning to the points. So the first, which is ground 4, concerns the module selling prices. The judge's starting point was the management projections in relation to this were inadequately explained or supported by independent data and sources. Now, in fact, this was an understatement because there was no evidence at all from the company to explain how and why the figures on the average selling prices had been arrived at. Now, the judge, therefore, had to base himself on the expert evidence. And the judge identified various problems with the approach of the two industry experts called by either side, but he then referenced Miss Glass's evidence. And if we pick it up in the Court of Appeal at paragraph 171, which is page 131, I think. So at paragraph 1, you see that there was no criticism on appeal of the finding that the reports of the two industry experts suffered from defects. He was therefore entitled to look at Miss Glass's report. Then her report came up with figures for selling prices lower than those in the management projections, and including the sunshot figures. And so the court said couldn't see how her report could have provided support for the management projections, and which the judge had found. But in the next paragraph, the Court of Appeal noted that the judge was of the opinion that these sunshot figures should be excluded, and the Court of Appeal said that in the last sentence, the only sensible construction was that once sunshot was excluded, Miss Glass's calculations were the most reasonable and provided support for the reasonableness of the management projections. But the Court of Appeal accepted that it wasn't open to the judge to conclude that the Glass projections supported the reasonableness of the management projections. And this is the important point that you have to then understand. The judge seems to have been of the view that it was swings and roundabouts. The fact that the Glass projections were a little lower in the earlier years, similar in the middle and higher in the later years, meant that on a rough and ready basis, the management projections could be accepted. But this is, the punchline is this, the important point. This was to ignore the extra effect on a DCF valuation of the later figures. So the simple point is that it's explained, in circumstances where the Glass projections without sunshot pointed towards later figures in the management projections being too low, the adoption of the management projections was not a fair decision as to the most reasonable projections.
But that surely is treating what Miss Glass was doing as putting forward a rival set of projections, where all she was saying was, my numbers come out pretty close to the management projections. At one point they're a little bit lower, another point they're the same, another point a bit higher. That gives me comfort in thinking that the management projections are reasonable.
But the question for the purposes of the DCF is, the problem is in a DCF not everything is equal. So it's actually...
I understand that the further out ones have more effect when you discount them to the present. But in terms of, if your exercise is not to come up with the best, you're not doing the calculation to see if you can come up with something better than the management projections, but just as a test as to whether they're close enough in the ballpark to be reliable, then I don't see what's wrong with the judge's reason.
Because, in our submission, what the Court of Appeal says in the next sub-paragraph is actually the important, that there was nothing to explain or justify the figures in the management projections. There was no witness called who could speak to it, and as the judge said, it was an issue where they were inadequately explained. Where he'd accepted the general validity of Miss Glass's analysis, but had qualified it by implication that the sunshot figures should be excluded, he needed to explain why he chose the management projections over her figures. And in the absence of evidence from the company about the preparation of the management projections, or reasons for his choice from the judge, it was wrong to prefer the management figures to the Glass figures. Now, in our submission, that is right. Because basically what you've got is the management projections, which no one has spoken to, no justification. You've got Miss Glass then has done an analysis and her projection. And in our submission, once you said, well, we can't rely on the management ones because they're not properly explained, it was wrong to rely on those figures rather than taking Miss Glass's figure and then to consider as what the effect of doing that. And 174 Well, it's 173 is very important in relation to which, however you're looking at it. So in the second sentence, the dissenters submitted that it was inappropriate in the view of the solar experts to the effect that rate of decline in prices was expected to slow, and the judge accepted this. The evidence for slowing rate of decline suggests that adopting a linear rate of decline fails fully to accommodate this aspect of the data. That was the critical point in relation to the DCF, and that's the point your Lordship was making to me, that it's important that you see that you're correctly projecting forward, particularly in the later years, the revenue. And what had gone wrong was that they were assuming a linear rate of decline. And that's what the Court of Appeal, and that's for 2022 and 23. And that's why they say that the judge was wrong to accept for use in the DCF projections which included a linear rate of decline. And that's actually the critical point here, that there's an element in the DCF which you can see is wrong because it assumed a linear rate of decline. And so the Court of Appeal was right to say that this was an error. Now, in fact, all the Court of Appeal have done here is they've said this is an error and then they've sent it back because, as you can see at 175, it was only at the last minute that the dissenters put forward a submission as to how to correct it. So at 176, they've said the parties should either try and agree it or it'll have to go back. But in my submission, that was right. Once you recognised that it was wrong to have a linear rate of decline for the purpose of the DCF, then that required correction. So that's that point. The capacity factors, now this is a not dissimilar point. Now, the capacity factor of an energy generating resource is as it's explained at 177 of the judgment at page 135, is its actual output as a proportion of its theoretical maximum output. And then it's explained at 178 that the capacity factor of the company's energy generating plants was a key aspect of the revenue that would be generated by its downstream power sales business. And then the next sentence is the key. It was therefore a relevant figure when forecasting future cash flows for the purposes of a DCF. So then at 179, you can see that the management projection forecast a steady capacity factor of 13.7% over the 7 years, whereas the dissenters were saying it should be higher. Now, if you go to, you can just pick it up at 185 on page 137, there's a reference to the cross-examination of Miss Glass, and if we just read the cross-examination at the top of the next page, and Mr. Salzido said, "You've given your evidence on that very clearly, and I just want to get a straight answer to the first part of the question. Now I've shown you the evidence of both experts. Do you accept that 13.7% flat, in other words, the capacity not growing, is actually below a reasonable forecast for capacity factors up to 2023? Answer, it looks like it could be, yes. Is that yes, it could be, or is it yes, it is? So yes, but how much below, I can't say. Maybe that's a better answer. So the evidence was that 13.7% was below a reasonable forecast, and that's why the judge found that that was right. He found it was probably below a reasonable forecast. That's set out at paragraph 186 of the Court of Appeal at the top of page 139, the first 3 lines. Now, having found that 13.7% was therefore not reasonable, the judge was not entitled in doing his evaluation to accept that figure. And as the Court of Appeal said, what was necessary to do, there were two, was to work out what the appropriate figure was. And that's what the Court of Appeal have done. They had a choice. They could have remitted it, but as they explained at 189 and 189, they didn't think that was proportionate, and so they formed a judgment of what was the appropriate.
The question is, if you've got good reason to think that your figure is too high, but you've got no basis for knowing what a more accurate figure would be, well, is the only rational thing you can do to make up a number like the Court of Appeal did? Or is it rational to say, well, I don't have a better figure, so I'll settle for one even though I know it's unreasonable?
Well,
I mean, that's not much of a choice.
With respect, your Lordship has loaded the question so that one can only give one answer.
Well, if you show that they've used some data in their number, then I didn't see what it was. But,
sorry, I didn't mean to interrupt.
No,
I didn't mean to be rude.
No, you weren't at all. No, it's fair. I did load the question.
Yeah.
That's true. It's fair.
Yeah, but
well, what I was trying to get at, it wasn't entirely easy to know what to do when you can have good reason to think, well, this number is too high, but you don't have an alternative number to go on. What do you do as a judge? What
you do, I mean, if you look at what the Court of Appeal did, let's assume you were the trial judge at the moment. What the trial judge should have done is he should have said, well, 13.7% is static is wrong, and I've got to have an increase. So then on the evidence available to him, which might include, as inevitably these sort of exercises do, sort of putting your finger up in the air to an extent for doing the best you can. It's more than guesswork, but it's based upon the evidence you've got. You would form a judgment. Now, the question is, could you form the judgment that was at 191? And what the Court of Appeal said, it was the reasonable starting point is take the actual figure from 2015 and assume it didn't change in 2016. Thereafter, you reflect an increase because of the increasing use of trackers, but giving weight to the conclusion that Russo's projections were too high. So you look at that, you discount it, and then they've taken a figure. Now, that's essentially just saying, well, I'd say this is a conservative approach, that we're projecting an increase of 0.05% each year, starting at 14.35 and so on. Now, that's a judge at first instance could have done that, and in my submission, the Court of Appeal could do the same thing rather than remitting this issue. Because if it's remitted, ultimately, the evidence is going to be the same. The judge is going to have to reach a similar sort of exercise.
Russo's projections did have an incremental increase, did they, in the later years?
Yes. I can't remember. Do you remember what they were?
And was the incremental increase greater than 0.05%, or were his figures just too high
I think
from the judge's point of view? In other words, does the 0.05% adopt Russo's incremental figures, even though not his absolute figures? Or is that a reduction on the incremental element?
Sorry, I I don't know the answer.
But it does appear to be not just plucked out of the air, at least based on
No, it's
something in Russo's figures, albeit adapted.
it's a discount to what Russo was.
Well, they summarised 181, his evidence, I think. Or they summarised the judge's summary of his evidence on page 136.
Yeah.
So he was taking an increase to 17,
Yeah, when he was
from
going
14.5 to 17.5,
Yes.
he was doing 3%.
So
Yeah.
yeah, so what the Court of Appeal is doing is taking a much lower rate of increase. So I see the time. Those, unless there's any questions or further questions, those are my submissions.
Thank you, Mr. Howard. We're very grateful. Mr. Chapman.
I think 4 points in reply, if I may. The first starting with ground 1, where my learned friend identified by reference to the Court of Appeal's judgment at paragraph 148 that the relevant question is whether the court can have comfort that the merger price can be probative of fair value. We agree that that's the correct question, or at least a formulation of the question and the task that the judge had to perform. That was the approach adopted by the judge, who weighed all the various considerations and the expert evidence and concluded that he could have comfort in the merger price. In doing so, he found various uncertainties and flaws and concluded that those uncertainties and flaws needed to be reflected in the weight to be given to the merger price, which we then see that he considered on a holistic and comparative basis, considering the 3 alternative valuation methodologies and their relative uncertainties and flaws alongside each other. In making those determinations and evaluating those various different competing factors, it was the trial judge who was best placed to make those determinations rather than the Court of Appeal. And there was no good basis for the Court of Appeal to interfere in his evaluation of those matters. In reaching the conclusions that he did, the judge considered both the flaws that he had identified in the merger process, but also the effect or likely effect of those flaws on the outcome of the merger process, and concluded that notwithstanding the presence of those flaws, the merger price could be relied upon. The 2 final points on this aspect of the merger price. The first is that, with respect in our submission, one shouldn't be too distracted by formalistic characterisations of where the burden of proof lies on these matters. The company puts forward the merger process and relies upon it. The dissenters then went about challenging the reliability of that process, and the judge concluded that the challenge failed and equally concluded that reliance could be placed on the merger process, and no criticism could be made of the judge and his approach in that regard. And the final point on this first topic is one which no doubt my lords are acutely aware of, which is that while some assistance can be derived from the Delaware jurisprudence and procedure, one has to keep in mind, as the judge did, the differences between Delaware and Cayman procedure, and in particular, when it comes to weighing the reliability of the merger price, the somewhat more onerous standards that are applied to companies in the Delaware procedure.
But is it correct that in at least in 2, I think, of the 3 cases referred to, what the Delaware court was actually doing was to say that the merger price should basically be used as the fair value?
That's right.
It wasn't just a matter of, so what it was requiring was stringent conditions to say this is what we're actually going to treat as the fair value, as opposed to what conditions you might require for treating it to be an element of the fair value, which might be less onerous.
My lord, I believe that's right. So in Solera, for example, the court rejected entirely the use of a DCF, which is what the dissenters were relying on, and relied entirely on what they called the deal price, the merger price, as we've been calling it.
Well, I think in the second case, I can't remember what it was called, they sent it back suggesting that the court might like to place entire reliance on the merger.
Price in Dell, yes.
No, the second one.
DCF, where it was one third, and they sent it back.
Yes, that's right. The second point is really related to the first, which is that, of course, the judge considered the various factors in favour and against reliance and the reliability of the merger price. And one of those, and an important one of those in favour of the reliability of the merger price, was the vote and its importance. And I was just going to give my lords the references here. It's in the judge's judgment at paragraph 157, which is where he sets out his conclusion as to why the vote on the particular facts of this case was particularly powerful as a factor in favour of reliance on the merger price. That's page 321. And in doing so, he again relies on Miss Glass's evidence. He identifies the size of the vote, but also the identity of some of the key institutional shareholders in paragraphs 292 to 295 of her first report at page 4591. So that's the vote. And of course, that was one of a number of factors that militated in favour of reliance on the merger price, which the judge weighed, as he was entitled to, against all of the evidence in reaching the conclusion that he did. The third topic to touch upon is the city fairness opinion, where my learned friend submitted that whether the 13% cost of debt had been corrected was a matter of pure speculation. With respect, that does overstate the position somewhat, in that the judge's conclusions were based upon Miss Glass's evidence again. And of course, Miss Glass did a number of things in relation to the city fairness opinion. One thing she did, as my learned friend referred to, and indeed I did this morning, was to rerun the city model, but using her own model, but city's assumptions. And that produced a DCF valuation that was very close, and that provided a degree of comfort. The second thing she did was to identify the high level of debt in the model, which may have then provided an explanation of the high cost of debt, but also indicated the balancing effect of a relative higher amount of debt against a lower amount of equity. And the third important cross-check, which provided comfort about the reliability of the city fairness opinion, was, of course, not just the product of her analysis in rerunning the city calculations through her own model, but the starting point that City's calculated weighted average cost of capital at 11.6% was very close in any event to her own calculation of the weighted average cost of capital of 10.8%. So, albeit they may have got there by different routes and using different elements or different amounts and proportions for the elements of the calculation of the weighted average cost of capital, their conclusions were very close, providing further comfort in the reliability of the city fairness model. And I think I gave my lords the reference to the passage in her evidence where we see that earlier this morning, but in case I didn't, it was page 5114 at paragraph 186. My lords, the fourth and I think probably final subject I need to address is in relation to ground 2 and what it was that the Court of Appeal was to do, having rejected any reliance upon the merger price. Now, of course, our position before the board, as it was before the Court of Appeal, is that the Court of Appeal should not have rejected the merger price out of hand, and to the extent that one was considering the relative weightings of the different valuation methodologies, one had to do what the judge had done, which was to consider the three side by side, and that the judge couldn't be faulted in what he had done in that regard. In terms of how the appeal was put, one does have to look at the grounds of appeal, because I think it's fair to say that the position went somewhat further than my learned friend indicated in the course of his submissions. And could I just invite my lords to turn up page 528 in the bundle, please, which are the grounds of appeal. So these are now the respondents' grounds of appeal before the Court of Appeal. And if one just tracks through some of the paragraphs in the grounds, ground one, market price, one sees that what was said was that the judge erred in giving any alternatively excessive weight to the adjusted market trading price. And then at ground two over the page, at page 530, the same formulation for merger price, the judge erred in giving any alternatively excessive weight to the merger price. And that's then reflected at page 534, paragraphs 23 and 24 under the heading, my lords will see, ground 5, weighting and fair value calculation. And what was being contended by the respondents before the Court of Appeal in their grounds of appeal was that the judge erred by giving any weight, alternatively by giving as much as 30% weight to market price. And then again, same formulation in paragraph 24, the judge erred by giving any weight, alternatively by giving as much as 45% weight to the merger price. And then finally, insofar as the grounds are concerned, at page 536, paragraph 30, in light of the above, the judge erred by failing to give the DCF valuation 100% weight, alternatively by failing to give it greater than 25% weight. And that was also reflected in the skeleton argument of the respondents in the court below, page 606, paragraph 144, again under the heading weighting, where the submission was made that the only approach reasonably open to the judge was to afford those prices, that's market price and merger price, zero weight, or alternatively lesser weight than he did, and therefore to afford the DCF valuation 100% weight, or alternatively greater weight than he did.
Just give me the page reference again, I missed that. Sorry.
I'm sorry, my lord.
No, it's my fault.
606.
Thank you.
So what the respondents were arguing on their appeal before the Court of Appeal is it's either zero for merger and or market, but if not zero, less than the judge, and it's 100% for DCF, but if not 100%, more than the 25 given by the judge. So all of the various different permutations which I indicated were available on the appeal were in fact available, at least in theory, in that if the Court of Appeal acceded to the appeal in part, but not fully, and revisited the weightings, the Court of Appeal was being asked by the appellants, now the respondents, to give different weightings, lesser weightings for merger and market price, increased weightings for DCF, anywhere between, on the DCF, the 25% found by the judge and 100%, and conversely for merger and market price, anywhere from 45 down to 0 for merger and 30 down to 0 for market. And so, really without further explanation by reference to those documents, that's why we maintain the submission, that it's really not fair or accurate to say that the appellants before the board should somehow have sought to accommodate all of those various different possible permutations in a respondent's notice. Indeed, with respect, it's quite difficult to see what a respondent's notice would have looked like to take account of every possible intervention that the Court of Appeal might have made in the relative weightings given to the three valuations. Which really takes us back to this point, which is if the Court of Appeal was satisfied that the judge's weightings needed to be revisited, then it had to go back and revisit the three valuation methodologies alongside each other, rather than proceeded as it did in knocking one out and leaving itself with only 2 remaining valuation methodologies to divide its weightings between. And having reached that point, if that really was going to be the point that it reached, one obvious way to avoid the vacuum or the black hole as it's been described, as my Lord Lloyd James said, was obviously to invite further submissions based on the findings that the Court of Appeal had then made as to its concerns, its greater concerns about the merger price methodology. My Lord, I don't think, unless I can assist any further, I need to say anything more about grounds 4 and 5, other than they were quintessentially matters for the judgment of the trial judge.
Thank you, Mr. Chapman. I don't think there are any further questions for you. Thank you very much. Mr. Chapman, Mr. Howard, we're very grateful to you and your juniors for your written and oral submissions in this complex matter. We're also very grateful to those sitting behind you for the preparation of the case. The Board will take time to consider what advice we will humbly tender to His Majesty. Court is now adjourned. Thank you very much.